The second affirmative defense that could apply to an aggravated DUI causing injury or death case is supervening causes. The defendant concedes that he was under the influence or over the legal limit, that there was an accident, and that someone was hurt or killed. But the defendant argues that his acts had absolutely nothing to do with the cause of the accident. Most often, the affirmative defense of supervening causes gets raised when the defendant has a medical condition. The case of People v. Way was decided by the Illinois Supreme Court in 2017. Keep in mind, this case happened before cannabis was legalized, so back then, the defendant having any amount of cannabis in her system was a strict liability DUI. The defendant's son, who was also the person who got injured, told police that right before the accident, the defendant suddenly fell asleep at the wheel. The defendant did have a history of sudden drops in blood pressure and wanted her doctor to testify as much. The court said, look, if this doctor can testify that the defendant's unforeseen low blood pressure was the cause of the accident and that cannabis had nothing to do with the accident, then the defendant should be able to present the affirmative defense of supervening causes. But where the defendant's doctor can only speculate that her unforeseen low blood pressure was a possible cause of the accident, the trial court did not err in refusing to give an instruction on the affirmative defense. The takeaway here is that it's tough, but not impossible, to get the court to give the jury instructions on supervening causes.